appeal is a matter of Comptroller-General or patent designers and trademarks and emotional perception and value.
Can I first of all express our thanks for the transcripts that came through overnight? Very helpful indeed. Thank you. Right, so I think we're on to point 5 now, aren't we?
Yes, we are, my lady. I'm moving on to my point 5, which is if the established law for ground 4, which is the established law for ground 4, if the comptroller is right on either grounds 1 or 3, then my learned friends need to show a technical contribution to take their claim outside of the exclusion. And as regards the law, the fundamental point at this stage is that if neural networks are just a particular type of computer program or a mathematical method, then we say there is nothing special about them when it comes to the law on technical contribution. They stand to be assessed on the established law, Aerotel, Vicom, Gale, Symbian, and the rest. They should be applied in the same way that we usually apply them to other computer-implemented inventions.
Sorry, you're going to have to slow up a bit.
I'm sorry, my lady. So what I'm saying is that all of the established case law on computer-implemented inventions remains as applicable to artificial neural networks as any other computer-implemented invention. We say nothing changes, and importantly, nothing needs to change. Now, we've summarised the law in overview in paragraphs 15 to 22 of our skeleton. And my learned friends don't seem to disagree as to the need to change the law or approach it in a different manner. They've got...
Well, as I understand it, it's common grounds that we should apply the Aerotel test.
Exactly. Exactly. My learned friends do raise 2 points in passing. Namely, do we still need the 4th Aerotel question? That's their paragraph 48. And secondly, does amendment to Article 52 in EPC 2000 make any difference to the exclusions? That's their paragraph 32 to 33. Well, in each case, my learned friends immediately say that they probably don't make a difference to this case. On Aerotel 4, their whole point is that it makes no practical difference. And on EPC 2000, they say expressly that they don't think it matters in their paragraph 53. Now, we agree that these points are a sideshow because they don't make any difference. We disagree with whether it's desirable for this court in this case to start looking at those areas. So as such, I don't propose to deal with them unless either my lady or my lords need further assistance with them, or if they become relevant in the course of my learned friend's submission.
No, carry on, thank you.
I'm grateful. That takes me to my 6th point, which is ground 4, that the judge was wrong to find that the claimed invention involves a substantive technical contribution that avoids the exception. We pick it up in actually my learned friend's skeleton on page 78 of the bundle, which is page 98 of their skeleton. And here my learned friends rightly acknowledge that we only get to ground 4 if the comptroller is right on ground 1. Just a little side note on that ground 3 needs to be taken into account as well. Now, assuming we are here on ground 1, at this point we have a claim which as a totality is to a computer system. And we know from Aerotel, as my Lord Justice Arnold reminded me, that we need to firstly properly construe the claim, secondly identify the actual contribution, thirdly ask whether that actual contribution falls solely within excluded subject matter, and fourth, check whether the actual or alleged contribution is actually technical in nature. And sufficiently construing the claim has been done for the purpose of this appeal, with the agreed position as to the inventive concept and the agreed position as to the meaning of claim 4, both of which we set out on page 3 of our skeleton and we looked at yesterday afternoon. When it comes to identifying the actual contribution, my learned friends start with their paragraph 98, picking up what was said to the judge below, that the actual contribution was the sending of the recommendation message over a communications network to the user device. Now, we can see that in the judgment, and it is helpful to focus our attention on this as to what target we're dealing with. It's in core tab 7, it's 105. And it's paragraph 68. And in the middle of the paragraph, just after AT&T, the technical effect relied on by emotional perception in this respect is the sending of an improved recommendation message. That is how it was advanced below. And at paragraph 74, that, having gone through it, the judge agrees with Mr. Chacksville's case on this point. And this point is that technical contribution. That's what we challenge in the judgment, and that's the way in which we advance this part of the appeal.
Well, can I just ask about that? Because is it your understanding that that is an accurate account of the applicant's case before the judge? The reason I ask that question is, even if it is, I'm not sure it corresponds to the way the applicant put its case before the hearing officer. Now, that's not necessarily any criticism of the applicant, but I'm just trying to see how the arguments have evolved.
I believe it may be something to check with my learned friend, but I believe that's what it was accurately put before Sir Anthony Mann. I would need to check back precisely as to the hearing.
And the reason why I asked the question is it stems from the point that I raised yesterday. If the claimed method is no more than a method for presenting information as to aesthetic choices, then that's all excluded subject matter.
Right.
And my understanding is that at least before the hearing officer, the applicant's case was to say, no, 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 this is not an invention about the presentation of information as to aesthetic choices. This is about pairwise comparisons of semantic content, forcing the way in which the ANN works with the property space through the back propagation. So the focus of the argument, certainly before the hearing officer, was not about the output of the method. It was about what's going on in the core technical steps in the method. And that's why I'm wondering if what's said in paragraph 68 is entirely accurate.
My Lord, I believe that by the time it got in front of Sir Anthony, what is in 68 is accurate. It's the way in which we have addressed this on this appeal. And when my learned friend deals with, I'm going to go through the points that he makes specifically in ground 4, under this heading in ground 4 in a moment. And what my learned friend never says anywhere in this section is that the sending of the recommendation message over a communications network isn't the actual contribution for the purposes of the error test. So insofar as my learned friend's position has moved from where it was before the hearing officer, this is firmly where he's pinned his colours to the mast at this stage of the matter. So indeed, I'll go through the 4 specific points that my learned friend makes in some detail. but it's convenient to guide our submissions, first of all, by looking at the established position which applies to claims of this nature, where the actual contribution relied upon is some sort of final message or some sort of final file provision. And we can actually pick that up on protecting kids, which is the relevant part is quoted in the judgment below, paragraph 72 on page 106. And here, Mr. Justice Floyd is saying that in the case before him, he's unable to accept the submission that there was no relevant technical contribution. That all, of course, depends on that case. But in reaching the conclusion, he starts with the proposition, which is accepting that the generation and transmission in that particular case of an alert notification to the user is not a relevant technical process. And he goes on to say, referring to Gemstar 1 and Gemstar 2, plainly it was correct in that case on 2 of the 3 patterns. And the essence is that the starting point on the well-established law is that the claims that have messages or files coming out of what's otherwise a computer system, they don't count unless there is something more, something which is technical. Because indeed, outputting a message or a file is what computer systems that interact with users do. And if merely sending a file result was good enough to avoid the exclusion would rarely, if ever, apply. All forms of communication systems, and certainly data retrieval systems, end up giving something to the user. What is required is something more than a mere output.
Well, and something more which is technical in nature.
Absolutely, yes. Lord. Absolutely. And with that, I can pick up the 4 points that my learned friend makes in his skeleton as to why the UKIPO's case, or the Comptroller's case, that there isn't anything more, is wrong. At paragraph 100, the allegation is made that the Comptroller has taken the wrong approach to the law and has ignored features of the claim, and so on, effectively wrongly identifying the actual contribution. We simply don't understand that. As we say, it was my learned friend who identified the actual contribution. That's what we're addressing. But more importantly, nowhere in my learned friend's paragraph 100, before he moves on to his next point at 101, does my learned friend explain what is missing from his own actual contribution. Now, we entirely accept that at various places in our skeleton, we have pointed out that he can't claim as part of his contribution things like ANNs themselves, or trading by backpropagation, or NLP analysis tools, or feature extraction, the timbre, beats per minute, and the like. But my learned friend is rightly not putting those into his actual contribution. His actual contribution is the sending of the file. And just to be clear, it's just the old music file, totally unaltered, provided exactly as it would be from any other or any prior art music streaming system. Nothing like the V-file vector is output from the system. The user has no idea how the file selection is in fact taking place, and it could be random. As far as the users see, they ask for a file recommendation and they get one. Nothing else.
The point is, as I understand it,
external.
just to be absolutely clear and precise, the point I think you're making is this: looking at paragraph 100, what is said there is, in the second sentence, is the UKIPO refers to the fact that the network is conventional and the message is standard in form. And that's true.
Yes.
And I think it's fair to say not in dispute. The point is there is something more, in a sense, and what's more is that the file, the message, is a music file, to take the music example. And then that is more than a message. It's a music message, and the word message is doing some work in that sentence. So there is something more. The question then is the fact that it's a music file
Good enough?
good enough? And your point is it's not.
It's not.
Understand?
I'm grateful, Now, no doubt my learned friends would like to have more in his technical contribution, but but any attempt to pretend that the only reason he doesn't have it is because of some issue of the comptroller wrongly applying the law is wrong. The actual contribution has been identified by my learned friend, and it is this recommendation message, the better recommendation message being sent to the user. Now we move then to my learned friend's second point at paragraph 101, where he seeks to object to the comptroller's characterization of the file being subjective. The essence of his first point within here is it's not just a file, it's a better file. Now, we discussed yesterday whether subjective was the right word. Subjective was the word used by the hearing officer, carried on in the hearing before Sir Anthony Mann, and it has some basis in the authorities the comptroller relies on. So that's why we've been using it. However,
which authorities are you referring to there?
It's our interpretation of the building structures case. I was going to come to that in a moment.
All right.
But having thought about it overnight, and in the light of the observations of my Lord Justice Arnold and Lord Justice Birss yesterday, we do think that aesthetic is a better characterisation. We mean the same thing. It's about a file recommendation which is better or improved, but only in the aesthetic sense, how it may be perceived by the end user. And indeed, the clue is in the whole way that my learned friend's clients advance their invention, that it is emotional perception. The whole point about the file selection is that it's not technical. It is an attempt to achieve emotionally perceived aesthetics by the user, rather than a simple if-then technical selection against something objective, such as similarity in beats per minute. And my learned friends seek to say that at the end of the day, even though the system is attempting to achieve an aesthetic result, the implementation is in fact deterministic, so it's technical. But we respectfully say this falls into the trap of thinking that the output of any computer program is technical because it's produced by a deterministic means. But saying the result is deterministic or involves technical processes and v-file vectors and things of that nature adds nothing to saying it comes from a computer. And we know that's not good enough. The second point my learned friends take in the section 101 to 103 is that the authorities don't establish that something which is merely subjective in an aesthetic sense is not technical. And we say it's the other way round. By definition, something which is subjective in the aesthetic sense is prima facie not technical, and the authorities have not come to a different conclusion. And we rely on two authorities, and we set them out in 42 and 43 of our skeleton. And we're referring here to the Yahoo case, 42 and 43 on page 40 of our skeleton, the Yahoo case and the building structures case. And my Lord Justice Arnold was right to pick me up earlier. The word subjective doesn't appear in either of them, and I apologise if I suggested otherwise. But just starting first with Yahoo. We say Yahoo is bang on point in terms of the specific question of whether the selection for a user, for example, of a song, is technical. The Technical Board of Appeals says not.
So, remind us, where do we find that?
Sorry, the extract of Yahoo that I'm looking at is on page 40 of my skeleton, my lord,
Right.
at paragraph 40.
And that's enough for our purposes?
I believe that's enough for our purposes.
Right.
The first sentence says it all, doesn't it? In the board's view, the selection of an item, for example, a song, for recommendation to a user does not qualify as a technical purpose.
Well, quite.
That's the point you're making.
Absolutely. Now, my learned friend says he has an answer to it. He says that this is a case where the Technical Board of Appeal was considering whether the feature in question was technical for the purposes of inventive step under Article 56. We agree. the EPO, just as the UK, requires that contributions made by a patentee under Article 56 are technical. But the origin of the technical requirement is the same for both Articles 52 and 56. It comes from the fact that patents protect technical solutions to technical problems and not subjective or aesthetic outputs. And we made that point expressly in our skeleton at the end of paragraph 41. And we respectfully say that my learned friend's answer to Yahoo, which is simply, well, this doesn't count because it's obviousness, inventive step, is no answer, unless my learned friend is also able to say that the meaning of technical is different for the purposes of Articles 52 and 56.
Well, I presume, to put a little flesh on what's a rather simple submission, that what you're pointing to is that the difference arises out of the application in the EPO of the convict approach. So it's two hurdles. So any hardware means you're outside of the exclusions, contrary to the view that we take in this country. And then after that, it's all on inventive step. And so when you look at the cases, formally speaking, the reasoning is no inventive step in a case like Yahoo. But the substance of it is because there's no technical contribution that isn't excluded.
Quite. We've always said, and we maintain, that although the procedural approach of going through the process in the European Patent Office differs from the approach we take in slightly different litigation setting in the United Kingdom, the result is the same. For my lady's benefit, in the European Patent Office, they do something which Lord Justice Arnold referred to as the convict approach, where they look at the excluded subject matter and obviousness all as part of the same story. It's a very low threshold to get through the initial exclusion, but then one looks more heavily at the technical issue alongside obviousness as all part of the same process. In the UK, for various reasons, we look at the exclusion entirely separately to the question of obviousness. But insofar as this technical issue is arising, be it for the purposes of Article 52 or 56, we say there's absolutely no reason to take a different view of technical in the two closely related issues as to patentability. So we
It's
say,
never been suggested that the EPO's approach to the answering the question of what is technical is different from that in the UK.
I don't believe so,
as far as I
Lord. Yeah, that would be a significant departure between not just the procedural approach
Exactly.
in the two jurisdictions. It would lead to very different results.
Can I just understand one more thing about this Yahoo?
Mhm.
That statement of principle doesn't depend on the basis for the recommendation, does it? It's not about the fact that the recommendation, because it's not focused on this case. So, for example, as I read that statement, that would be the same if the recommendation was based on beats per minute.
I believe that would be the case, yes.
Because it's a song recommendation, effectively, that is why it's not technical. I'm
Yeah,
asking you, do you agree with that?
I think that's absolutely right, my lord. Yes. So we say, my learned friends actually have no answer to Yahoo, not one that bears scrutiny. But then moving on and actually moving much closer to where we are, we rely on the building structures case, our paragraph 43. And again, the full authority is in the bundle, but I think the relevant extract, certainly for my purposes, we've quoted in our skeleton. This is actually specifically in the context of Article 52. And in building structures, the output from the claim system was considered not of a technical character because it depends on the skills and preferences of the particular group of users for whom the invention is intended. In other words, whether it's a better output depends on the user's perception. It is a perception based on aesthetic appreciation. And we say, that's exactly our point, to which the only answer my learned friends have in their paragraph 103 is that this case relates to the wrong exclusion. They point out that building structures is a case concerned with the presentation of information exclusion rather than the computer program or mathematical method exclusion. But in that defence, my learned friends totally overlook that the error test, which is what we're supposed to be applying, applies equally to all of the exclusions. They all require the actual contribution to be technical, and technical can't have a different meaning for one exclusion as opposed to another. And the relevant paragraph of the applicability of the test to all the exclusions is paragraph 41 of Aerotel, which is in Authorities 4, page 60. If an aesthetic contribution is not a technical contribution for the purposes of the presentation of information under the Aerotel test, or under the EPO's consideration of Article 52 2D, then it's not technical for any exclusion. They're all based on the same requirement. And we respectfully say there's nothing in my learned friend's second point either.
So forgive me for asking another question, but putting it in my own terms, if one thought there might be a pleading point to be said that presentation of information exclusion hadn't been mentioned, the answer to it is this is about what is or is not technical. And this is certainly front and centre of this case.
Absolutely. And my learned friend's third point then picks up at 104. He starts third. This is where my learned friend seeks to read on in the extract we started with protecting kids at paragraph 34, which is quoted in the judgment of Course 7, 106. I can pick it back up there. It's the easiest place to keep going back to it. Which also incorporates consideration of GEM Star 3. And protecting kids and GEM Star 3 are, we say, two cases marking something of a high water line where the courts in the United Kingdom have found that sending a message or file led to an external technical effect. And we pick up both in some detail at paragraphs 45 to 58 of our skeleton, not least because they're the authorities relied upon by the judge below. But in both cases, the starting point is that a mere message or file transfer is not enough. But the court found in those cases that there was something more in each case. In GemStar, two patents were rejected, what I call GemStar 1 and GemStar 2. Two patents were rejected on mere provision of a final result. But a third survived, and the reason it survived is because a signal caused an external video recorder to start and stop recordings of programs. And we respectfully say this is actually a classic example of a computer-implemented invention having an external technical effect in the outside world, which is one of the signposts from AT&T, controlling external apparatus. But there's no equivalent in the claim in question. The claim is not controlling any external apparatus. It's providing an unaltered file plucked out of its database. With protecting kids, Mr. Justice Floyd explained that the system as a whole had an actual external physical effect, likening it to GemStar 3. And my learned friends can't take that approach for the same reason. And then further, Mr. Justice Floyd went on. My learned friend seems to say that these are two separate points. Certainly one reading of it suggests that Mr. Justice Floyd is looking at building both points together. But taking the second point, because that's where it differs from GemStar 3, Mr. Justice Floyd held that when used in conjunction with the external system, the overall result was an improved monitoring of the content of electronic communications. And it's worth picking up, just in the quote on page 106, 4 lines up from the bottom. The monitoring is said to be technically superior to that produced by the prior art. My learned friends seek to say that they have an improved recommendation system, but notably what they cannot say is that the qualifying phrase, which we say is all important to Mr. Justice Floyd's determination in protecting kids, my learned friends can't say that their recommendations are technically superior to that produced by the prior art. We say that's for 2 reasons. First, the recommendation isn't technical at all, as we've already discussed. It's aesthetic. That perhaps doesn't take us very far. But the second reason is that there's no basis for saying that the recommendation is superior in a technical sense, because there's nothing in the claim which enforces the required superiority, even subjectively, which is the only way we can judge it. The recommendations may be better or they may be worse than the prior art. Because I listened to Wagner's Ring Cycle, a prior art system based on listeners who liked this also liked, might recommend Wagner's Master Singers of Nuremberg. One can understand that, and one can well see that many listeners would think that it was a better recommendation than that in the patent, because the patent suggests hard rock recommended as an alternative, having listened to Wagner's Ring Cycle or some other aspect of Wagner. So question whether there's superiority at all. Overall, we simply don't have a result which is clearly technically superior to that produced by the prior art. It's different, but it's not better. And picking up a point similar to that made rightly by my Lord Justice Arnold yesterday, even if the claim covers some implementations where the recommendations could be said to be better than the prior art, the claim clearly also includes implementations that are not. So the claim as a whole is bad. Now, my learned friend's conclusion towards the end of his paragraph 105 is that we have misread Protecting Kids and Gemstar, and that these are actually authorities for the proposition, and I'm quoting him here, he says at 105, those cases both make the same point, 4 lines up from the bottom, namely that an extended transfer of data will usually establish a relevant technical effect external to the computer. And we say this simply isn't made out. In fact, we say it's flat contrary to the starting point in Protecting Kids, and was the same reason for refusing Gemstar 1 and Gemstar 2, which didn't have the something more which the court went on to find in Gemstar 3.
Just to look, I'm sorry, Mr. Professor, looking at what Mr. Justice Floyd, as he then was, said at the end of that paragraph that you've referred us to, I'm just trying to work out whether the word superior was doing the work that I understand your point. You say that there's nothing in this case is your position, and no doubt the opponents don't agree, to justify the word superior. But wouldn't the logic of what the judge there was saying be just the same if it had said different? It doesn't have to be super. For the purpose of the exclusions from patentability, I don't understand why it's necessary to be superior as long as it's different.
If it was technically different to that produced by the prior art. It isn't what Mr. Justice Floyd said.
No, indeed.
If Mr. Justice Floyd, or if it was put to me as I think it is being, would technically different do, actually the bit that we're looking for is technical.
Yeah.
So arguably the claim, arguably to take it to the extreme, if the result was technical but inferior to the prior art, it would still tick the box to move one out of the exception.
That's my point.
Yes.
So in other words, it may be an issue on inventive step, that's a different question.
Yes.
But the purposes of understanding what the law is as applicable in in this context. The critical thing is the technical rather than, and the difference. There's a difference.
Yeah, absolutely so. And one can actually see that if we fall away from the exclusions and we look at that, with a simple case such as the better mousetrap. Of course, every patentee says, here's my new mousetrap. It's better than anything that went before. The allowability of that patent application doesn't depend upon the puffery of the patentee as to whether it's better or not. You produce your new super complicated and 3 times the price mousetrap. Some users might like it. You might be able to market it very well. But whether or not it's better than the age-old sprung-loaded mousetrap is neither here nor there. When it comes to assessing the allowability of the patent, we're interested in whether it's new, whether it involves an inventive step, and then exclusions.
Yeah, I mean, it's not normal for applicants to say that their claimed inventions are technically inferior, but of course there are exceptions. So the case where the application is a claim to a product or a method which is acknowledged to give slightly inferior results from a purely technical perspective, but is significantly cheaper.
Yes.
That might be an example.
Absolutely, my lord. Absolutely. So, just picking up that final point at the end of 105, we say as far as you look at protecting kids and including its consideration of GemStar, the authorities are actually flat against my learned friend. They establish that my learned friends need something more than just sending the file, and that has to be something technical, and nothing has been identified. We also pick up this point at our paragraph 57, where we point out that the judge rightly acknowledged that something more than merely sending a file was needed. But having done so, he doesn't identify the criteria he had in mind. What he says is they are not technical criteria in the sense that they can be described in technical terms, but they are criteria nonetheless. Now, with respect to the learned judge, we have no idea what he meant.
I'm sorry, which paragraph is that?
Sorry, that's in the judgment.
You're talking about paragraph.
I thought you were talking about 57 in your skeleton argument.
Yeah, I was in 57 of the skeleton argument referring to the judge. Let me see if I can find a reference from that.
76.
Oh, I'm told it's 76. I'm grateful to my learned friend. So it's in the middle of the block at the top of 708. It's not just any old file.
I'm lost now. I don't know what 708 means.
Sorry, it's 108. My lord, my handwriting is bad. It's not just any old file. It's a file identified as being semantically similar by the application of technical criteria which the system has worked out for itself. So the output is of a file that would not otherwise be selected. It's a different file, is all the judge seems to be saying. And just above that, the bit that I was picking out was true it is that those criteria are not technical criteria in the sense that they can be described in purely technical terms, but they are criteria nonetheless. And the AEN has certainly gone about its analysis and selection in a technical way. It's not just any old file. But the problem we have with that is it is just any old file. That is what's being provided from the system. All of the discussion that the judge is involved in 76 is about how the data processing apparatus, how the computer program works. Any data processing apparatus will have technical determinations within it, very often of the if-then-else form that my learned friend is so keen about. But all of that's excluded. What we need is this external effect, or in taking for this particular type of case, the provision of something which is a technical contribution outside of all of that data processing. And that brings me to my learned friend's fourth and final point, where in my learned friend's 106, where he is relying or seeking to rely on the contention that an ANN itself is a technical thing. So that will do. We respectfully say the approach takes the case nowhere. It's no different to saying that a program computer at the heart of any computer implemented invention is a technical thing, so the exclusion doesn't apply. Such an approach is in direct conflict with a whole line of authorities, summarised as far back as Gale's application, which we refer to in our skeleton at 17, which says that if you can't patent the program, you can't get around it by patenting the program computer, by saying that the computer is technical. In any event, if one actually follows up the reference in 106 to paragraph 78 of the judgment is there relying on the point about his understanding that the comptroller was accepting that hardware ANNs are technical and allowable. So with the concession having fallen away, it's quite difficult to see what the basis is to my learned friend's continuation in 106. And of course, it doesn't help him because, as my Lord Justice Arnold pointed out yesterday, the claim covers both software and hardware anyway. So even if I'm wrong about neural networks being computers and having computer programs, we're back to the breadth of claim problem that the software implementation, there isn't any hardware for my learned friend to rely upon. So standing back, the contention that the file output is a technical contribution, we say goes nowhere. Protecting kids establishes that the mere file transfer or file recommendation isn't enough. More is required. That more has to be technical. And my learned friends have been unable to point to anything beyond the mere file being an improved recommendation, which is not technical for the reasons we've discussed. We can't find anything concrete identified in the judgment in respect of the file transfer. And my learned friends, we say, don't seek to say otherwise. And for that reason, when ground 4 is approached on this well-established basis, there is no technical contribution which lies in non-excluded subject matter, and the hearing officer was right to reject both claims 1 and claims 4. And for that reason, the appeal should be allowed. My lady and my lords, unless I can assist with anything further, I see my Lord Justice Arnold is looking at something.
I'd still like to come back to how I understood the case was put before the hearing officer, because at the end of the day, the question for us as for the judge is whether the hearing officer was wrong.
Yes.
And so if we look, I mean, I know it's reproduced somewhere in the judge's judgment, but I can't put my fingers on it just at this second, so I'm looking at it in the hearing office decision itself, which is supplementary bundle tab 6, page 117, paragraph 43. And the key sentence is the third sentence quoted. The fundamental insight is in the training of the ANN, which analyzes the physical properties of the file by pairwise comparisons of training files. And then it goes on through the way in which the distance in property space is converged to reflect the differences in semantic space for each pair of files. Now, the point about this way of looking at it, as it seems to me, is that although, of course, as the last sentence of the quotation shows us, the end result is a recommendation to the user of a file, the focus of the submission is upon the process by which the ANN is trained. And so that's why it seemed to me And if you read the hearing officer's reasoning, he goes on to address the various ways in the argument was put to him. He identifies 3 different ways in which the argument was put, but it's all based on this fundamental proposition, which is not about the file recommendation that's the end. It's about the process by which the ANN is trained. Now, let us assume for the moment that Mr. Chaxfield adheres to what he said to the hearing officer. Why do you say that that is excluded?
Yes, my lord. So the identifying the contribution, which occurs at 53, is step 2 of error. One then has to move to step 3.
To be sure.
Which is going through it and removing the things, or removing from the actual contribution the matters which are excluded subject matter.
Indeed, but that's why I want to focus on that 3rd sentence,
yes,
which seems to me to be the gravamen of the way it was being put before the hearing officer.
But having gone through Aerotel question 3, what my learned friend is left with is the file transfer. Because it's fine to say there's a distinction, of course, between what the patentee has done. Whenever one gets a data processing patent, there are pages and pages and pages of the specification which are all about the clever data processing. And they all get put in to the description of the patent. They all get put into the claim, certainly at some level of detail, because that is what the patentee has expended his skill and effort and labour doing. That's the bit he thinks is clever and new.
So in very simplistic terms, what you're submitting is that a clever computer program is still a computer program.
Exactly. Unless it comes out through one of the recognised ways of getting outside of the computer program as such exception. And we know from AT&T and the like that sometimes you can say it's a better, you end up with a better computer, that you end up with a more efficient computer, things of that nature. They aren't the ones that have been raised in this case. My learned friend is going for the signpost of an external effect on the real world. It is the transfer of the external program. Fine, he's entitled to do that, but then he has to meet the test that that external file transfer has to be technical in character, and what he has identified doesn't meet that test. Because the consequence of allowing oneself at the final stage to delve back into all of the patentee's teaching and pick things out of his data processing system basically means unless the patent is actually invalid for novelty or obviousness, there will always be something new in his method, and the exclusion will never apply.
And just to complete that, I think what the hearing officer, the way he did what you've just described, ends up in around about 68 and 69. So they asks the question in 68, what task is the program performing? And then in 69 deals with the provision of the user of the approved file recommendation, and says, however, that, this is the end of 69, such a beneficial effect is subjective and cognitive, and we move back over subjective, we don't need to go back over that.
Exactly, my lord. And one can actually pick up an in-between process at 61, where this specific issue of the training approach is being considered by the hearing officer, and he's saying the problem is with this bit is it's still nothing more than a computer program. And then we end up, as my Lord Justice Birss says, at 68, 69. My Lord and my Lady, and my Lords,
Don't worry.
I'm happy to assist further if there's anything else still troubling you. But otherwise, there's my submission.
Can I put something? Can you tell you what bothers me? Imagine this. Imagine I was a jukebox manufacturer, 1950s Happy Days kind of jukebox, which has got no computer in it anywhere.
Yes.
Might have some electronics, but nothing anyone would call a computer. It's entirely electromechanical device.
Yes.
And it's completely, it does what it's told. User comes along, selects a song, it plays the track. And you invented a new one, and the new one has an electromechanical system in it, which proposes another track, not just the next one in the pile, but has some method, which one might say in a very, very broad sense is an algorithm, based on some view about what the next track the user might like to listen to might be, given the one they've chosen. Okay,
Yeah.
and you could make it. I don't know. It doesn't matter. But I wondered whether you could make it by saying each of the discs has a slightly extra little bit around it, so they all have a different diameter that you can use a mechanical measurement to check. It doesn't matter. And it works by you play a song, and when the song's finished, on the great, you remember those things? They had all the songs were written out on the front, and it simply put a light beside the next song it was proposing, and the user could choose to say yes or no. I have a funny feeling that if I came up with that invention and applied for a patent for it, no one would say that there was anything wrong with it or anything excluded by anything at all. But the line of reasoning which says that the recommendation of a song is not technical strikes me as applying to that invention in a way which invention suggests might come as a surprise to both the inventor and all the people who were thinking about it. And I don't know. I genuinely don't know what the answer is, and that's why I wanted to ask you the question.
I think just to clarify, the machine I have in mind is it spins some sort of random disc, and wherever the disc lands, it turns a light on for me. It's a sort of random number generator.
It doesn't have to be random. No, I'm not saying it has to be random.
Okay, fine. Some form of selecting. So let's look at the patent.
It's a recommendation.
A recommendation. Let's look at the patentability of that system. It is implemented on the way my law puts it to me as a purely technical system. So the allowability of that invention doesn't cover the exclusions. So we're looking at the full gamut of what the patentee has put forward, of all the things he's claimed, of his complete system, including the recommendation engine, if I call it that. He's come up with a new way of doing that, and it's new, and it's quite clever how it does it, so it meets the inventive stage. The claim is allowable. You don't ever start having to look at bits of the system and saying what's really going on here, the ultimate result needs to be something technical, because the thing as a whole is technical.
But it's technical not because of the output, the recommendation. The recommendation is still within the realm of aesthetics.
Exactly.
It's technical on this hypothesis because you've got a piece of electronics
Or mechanics or whatever, doing the job.
Produces that output.
Absolutely. And the problem with when you then come to the exclusion, we do the same thing, but we do it in a computerized system. There's still cleverness. I don't take this from my learned friends at all. There's still cleverness in the system of having to do the selection. The problem is that because of the exclusion, anything that's clever that amounts to a computer program doesn't count. It's not claimable. So what we've got to look for is something beyond a computer program, beyond a computer program as such. And rightly or wrongly, the way the authorities are trying to say, well, let's look at that new thing. And the thing that they're left with is then just the file recommendation. And it's not technical. As my Lord Justice Arnold very rightly points out, it's as aesthetic in the computer scenario as it is in the mechanical scenario. But the reason the mechanical scenario is allowable is because the guts of the machine are not excluded from protection. Whereas the problems my learned friend has, and it's a policy decision of the legislature, is that the guts of a computer program cannot be claimed. They're excluded. So he's left with what comes out. Now, sometimes in the case of Gemstar or whatever, it's being used to control some other system, and that's been found to be enough. There are, I don't need to go through the authorities as to where exclusion can be found, but it can be difficult with pure data retrieval systems, even though they may be useful, even though they may involve cleverness in putting them together, it doesn't mean that they drop through the exclusion.
Thank you.
Thank you very much indeed. Do you follow? Jed.
My lady, my lords, I'm going to address matters broadly but not entirely in the order my learned friend has. I'm afraid there's an awful lot to get to because a lot of what my learned friend said doesn't fairly represent my case and therefore doesn't engage in my case. So I am going to have to, in some senses, start right at the beginning on some of these points so that you understand the argument that is in fact being advanced and don't get distracted by Aunt Sally's that have been knocked down around. I'm proposing first to look at the application. There was a little confusion about this at times yesterday. I want to make sure that my lady and my lords have that right. I'm going to then turn to his grounds 1 and 2, which is, does an ANN contain a program for a computer at all? And that will involve a short look at the Act and questions of construction. And then I'm going to need to spend some time clarifying and correcting the way my learned friend described the technology yesterday. In my learned friend's submissions and skeletons, he runs, as he did before the hearing officer, arguments which we characterise as being the contribution approach which was rejected in Aerotel. And he was doing it just now in front of the court. So the point there is the contribution approach involves looking at a claimed invention, extracting from the claimed invention the inventive step, the clever bit, and then asking whether that falls within the exclusions. And the Court of Appeal on at least 3 occasions has said no, and that's Aerotel, and I'm going to need to show you that, because the approach that the Court of Appeal takes in Aerotel is what's called the technical effect approach, and that requires a consideration of the claim as a whole, identifying the contribution of the claim as a whole, and then asking whether or not that contribution has a technical effect. And you can very clearly, if one just thinks of the cases, see the distinction, because my learned friend, in response really to the question my Lord Justice Birss just put, says, well, this application fails because the clever bit, if I can use a shorthand, is in the ANN. If that's a computer program, nothing else matters. But in Vicom, the clever bit was a mathematical algorithm implemented on a computer. The method was allowable. In Halliburton, before my Lord Justice Birss, the clever bit was the manner in which the drill bit design was simulated on a computer. That was allowable. In Protecting Kids the World Over, the clever bit is the computer program that performs what was known as packet sniffing, comparing the results to a hash table. That was allowable. Gemstar, the, in that case, allegedly clever bit, was the new form of electronic programming guide. But the claim was not within the exclusion. And I'm going to show you why that is. But what those cases, and I can't think of a case which has got through the exclusions where the clever bit isn't in that form. I suppose Aerotel itself might be one. But the point is, if my learned friend's approach is right, it means almost every decision in which a patent has been allowed, an application been allowed to proceed, is wrong. And this is a really important point. And it's a really important point because this contribution approach was what the examiner took in prosecution. It's the approach the hearing officer took in his decision. Rightly, we say the judge appreciated it was not the right approach in the decision below. But also, I understand from my instructing attorney, it's the approach that's taken very commonly when looking at patent applications of this sort in the patent office. and it's an approach which is wrong. And that's why you'll have seen from my skeleton, we have dedicated a substantial number of pages to going through in detail the Aerotel decision, working back from Merrill Lynch.
So that's quite important, what you've just submitted. So what you're telling us is that the UKIPO routinely applies the wrong law.
Well, I will say this, my lord, in this case they applied the wrong law.
You've just told us that you're instructed that this is common.
I understand that the approach is commonly taken to look at what is said to be the inventive step and to focus on that and to put to one side features which obviously interrelate to it, because you have the message that results from the output of that thing, but which are not themselves independently what you would rely upon to support the arguments of inventive step. So it is an important point, my lord, indeed. So when I turn to the technical contribution arguments, which arise if I'm wrong on the first point about whether there's a computer program at all, then I will need to address you in some detail, I'm afraid, on the law, particularly as to Aerotel. And then I'm going to look at Vicom and a couple of other cases, but Gemstar and protecting kids as well in particular. And you'll understand we put our case on technical contribution in three ways. Firstly, that even if there is a program for a computer in an ANN, the invention properly characterized is a system or method of using a system to provide better recommendations and recommendation messages. And the point there is, as we'll see, Vicom is very clear, which is that if the invention is defined at a level above its implementation using modern technical means in the form of a computer, then, as long as that method itself is not within the exclusions, then the general position is you can have a patent.
So when you say better recommendations, better in what sense? What's the criterion of better?
My lord, can I come on to that? Because I'm very shortly going to look at the technical contribution and paragraph 54 of the hearing officer's, 53 of the hearing officer's decision cited in paragraph 24 of the judgment. And if you'd forgive me, can I pick it up together then? Because I think there'll be a number of points which I may need to address the court on, of which that is one. So that's the first way. The second way we put the claim is, even if I am wrong on that in any event, the sending of the recommendation message itself provides a technical character. And the third way is that the presence of the ANN itself provides a technical character. That's the point set out in paragraph 77 and 78 of the judgment. When we get to it, you'll see it's a little bit more nuanced than that, and the judge's position there is a little bit nuanced than I just portrayed it. But just to identify the main point, I think that will do for now. And then right at the end, we come to the mathematical exclusion, but I hope that will be short. So the application. Now the judge summarised the application in 4 to 13 of his judgment. And you may have seen from our skeleton that we also refer to Annex 2 to our High Court skeleton, which is in the supplemental bundle. Just for further detail of that sort of assistance. If my lords could pick up the judgment and start at paragraphs 8 and 9, where the judge sets out the two ANNs which are involved in the training process, and starting then with paragraph 8.
Sorry, you referred to two ANNs. I'm a bit puzzled by that. I thought the claim is to a single ANN.
My lord, in training, two separate ANNs are used. The semantic ANN and the physical properties ANN, and they are separate ANNs, although the results of the former are used to inform the training of the latter. In use, only one ANN is used, and that is the physical properties ANN.
And this explains, at least from my own subjective point of view, what was confusing me about yesterday, because I knew there were two ANNs involved, but the point is there's only one in the claim, but there are two in the training.
That's exactly right, my lord.
Thank you.
And you say, at the end, last sentence of paragraph 9 says this is the ANN, the physical ANN, which will be the final operative ANN in the system. That's the one that's used in use. Just the last sentence of paragraph 9. But just sticking with the, if I may, the first ANN, the one involved in the so-called semantic analysis. So this is used only in training, and what involves is taking.
Well, I'm sorry. Just can you show us where in the claim we find the two ANNs?
Okay, my lord. The claims are in the back of the.
So I'm looking at it in the appendix to the judge's judgment, and I'm looking at claim 4.
So I thought you said, Mr. Chaxford, there aren't two ANNs in the claim. There are two ANNs used in the training process.
Well, I think there might be a reference to the second ANN in the section referring to the training.
Because the claim includes training. That's
Claim 4 includes training. Claim 1 is a product by process claim, which claims the result of training.
indeed.
My lord.
But where in claim 4 do we find two ANNs?
Okay, my lord. So if my lord starts, it says a method of providing semantic relevant file recommendations in a system, including an artificial neural network having an output capable of generating a property vector in property space. So that is your property ANN, your paragraph 9 ANN. It's comprising A, training the ANN, so that's again the property ANN, and deriving a separation distance for each. Okay, and the first independent derived separation distance expresses a measure of relative distance between the first pair of training in semantic embedding space. So there is a reference there to the semantic embedding, although not the semantic embedding space ANN. But it then says where the first independently derived separation distance is obtained from natural language processing. And NLP is the ANN, which is used for the purpose of semantic analysis. So NLP is a type of ANN, and that is the semantic paragraph 8 ANN.
All right, well, I get that, but can we just look on to first letter B? In
Yes.
a back propagation process in the ANN singular, using output vectors generated at the output of the ANN from processing of multiplicity pairs to adjust weighting factors in the ANN, thereby adapting the ANN during training to converge distances of output vectors in property appended space towards corresponding pairwise semantic distances in semantic space.
Yes.
That all seems to be envisaging that there's one ANN.
Well, no, the ANN there is the ANN of the first sentence, which is the property ANN. You are converging by reference to the semantic distances which are produced by the NLP processing, which we just saw. So the output of the NLP processing is fed into the training, and I'll come on to that in a moment. But it's fed into the training of the property ANN, but then the property ANN is the only one which is used. You see at C, 2/3 of the way down the page, it's the trained ANN, which is the trained paragraph 9 property ANN, which receives the target data, that's the music track in our example, as an input, and which then outputs a file vector in property space for the target data based on processing in the trained ANN. File properties extracted from the target data. So file properties extracted from the target data is the language used in this application to talk about the physical properties extracted from the file data as opposed to semantic properties extracted from the text description associated with it.
Right, well that's helpful, but that explains why the method of claim 4 is a method that involves only one ANN, albeit you have explained that the training step uses output from a second. which is not referred to as an ANN in the claim, it's referred to as the natural language processing.
Well, the last paragraph on page 111 of the bundle is actually a step which involves the obtaining of, if I can just short circuit it, the output of the NLP analysis of a pair of tracks and deriving the separation distance, the difference between the two of them.
Yeah. Thank you.
So I think that's. I think what my lord said in claim 1 is correct, because that has an ANN which is characterised by the manner in which it's trained, it's product by process claim. And so they are slightly different by that. And that's why we said in our skeleton, although to date we've always said we're not sure claims 1 and 4 have any material difference. Given some of the ways we've always reserved our rights in that regard, and I've done that explicitly at every level so far, and have done so in our case here, there is a possibility that a difference could emerge given some of the arguments run by my learned friend, and I'll flag that where that arises. I think as he's developed it, it probably doesn't actually, but I do always reserve my position on that, and I have to date, and I continue to do so. The point being, sorry, my lady, the point being claim 1 doesn't have a training step involved. And certainly below, there was a focus by my learned friend, Ms. Edward Stewart, on the training step as founding the objection. And so there was some consideration as to whether claim 1 and claim 4 might have been different, given the focus at that level on the training process. Before this court, the focus of the UKIPO's case is a little bit different. And so the distinction probably doesn't matter, but I'll flag it where it arises if it doesn't argue.
You're absolutely right that claim 1 is a product by process claim, but the process is a training process.
Sure.
So in that sense, it does involve a training step.
In that sense, it does, but it doesn't actually claim a training step.
Yeah, well, this is why product by process claims are frowned upon. There we go. That's a different issue, as I
That is a different issue. I remember at least sitting next to Mr. Mead while he debated with my Lord Justice Birss in one of the Hespera cases.
My favourite subject, Mr. Chairman. I know my lady's very keen to see product by process.
Right, so sorry, if I can return back to my note. I was discussing paragraph 8 of the judgment, and I was just describing that in this ANN, a semantic, that's a literal, wordy description of the track is run through an ANN which can analyse text and then embed the track in what's called a semantic embedding space. As my learned friend said, text analysis of this type was established at the priority date, and this analysis could be done with an off-the-shelf NLP text analyzer, which I've just said is a kind of ANN. Now the output is a set of coordinates, and so it's called a vector, and those point to a particular location in the semantic embedding space. So if you imagine it just very simply in 2 dimensions for a moment, though obviously it's going to be much more complex than this, normally these vectors go from -1 to +1, and so your vector might say, for a particular song, it might say +1/2, -1/4, and then you can notionally draw a dot on a graph with a circle around it for that track. And then another track, or semantic description of another track, might have a different coordinate of +1, 0, and so that's quite far away on the other side of the circle, and so it's quite a dissimilar semantic description, or it could be close and then you get a similar semantic description. But the embedding, that's what the embedding space, it's imagining this as it were on a graph, but of course this is a graph that might have not just 1 dimension or 2 dimensions or 3 dimensions, but might have 150 dimensions, at which point one can't conceptualise it because our brains can't do that. But answering my Lord Justice Birss's question yesterday, the reason it's described as a vector is because it describes effectively the movement that has to be done from the origin at 0, 0, 0 to get to the point in the embedding space. Now, one should note here, and again, I think my Lord Justice Birss was making this point yesterday, that NLP simply looks at the words used and their, what you might call their geographic relationship in the text in a purely mechanical way. Now, whilst it manages to group texts which have similar meanings, it doesn't do so by having any understanding of that meaning. It doesn't work in that way at all. It's a mechanical analysis with no intelligence or understanding behind that. Now, for that reason, a human can't read an NLP vector and understand what it's indicating. You can't look at the numbers and say, oh, that corresponds to a text which says a happy light track with a summary feel or anything like that. Because the embedding space doesn't work like that. But what one does know is that whatever the semantic meaning of the text associated with a first track, another piece of semantic text which is closely associated with it in the embedding space will in fact have a similar semantic description, whatever that might be. And conversely, a description located distally to the first one will have a different semantic description, but again, without actually knowing what either of the semantic descriptions are from the vector, the pair of vectors. So what is done in the invention is then a scalar distance is taken between the two tracks. And just to be clear, by scalar, what I mean is it's just the distance, irrespective of whether it's up or down or left or right or forward or backwards or any of these other 150 dimensions. It's just the distance between the two tracks. And that's used in the invention as a measure of semantic similarity or dissimilarity. But as I've just said, without any understanding of what the actual semantic meaning of either of those tracks is from the vector. So that's the first ANN. The second ANN is the one that the judge refers to in paragraph 9. And there the tracks are analysed for their physical properties, for embedding in a physical property space. So this is a purely physical analysis, and so for music it might be based on, for example, beats per minute, tonality, rhythm, timbre, perhaps using a thing called a Mel spectrogram, which my learned friend showed at the court yesterday, briefly. The extraction of those physical features themselves is done by standard techniques known at the time. But it is those extracted features which are then fed into the physical ANN. And the physical ANN then processes those inputs to produce a final output vector of its own, which is the one that was referred to as V file that my learned friend was discussing with the court yesterday. But once again, that vector has no human understandable meaning. One knows it is based solely on the physical analysis because the only inputs are the physical features. But you can't read the vector and say, oh, this is a rock track or a happy floaty track with summary feel. And that's because
it wouldn't be the latter anyway. It would be a track with 180 BPM or 190 BPM or whatever.
Well, indeed, even that isn't right. And can I just explain why, my lord? Because there's in fact there's obviously a relationship. There's no obvious relationship between inputs and the outputs. My learned friend, in fact, maybe I could show you this. In the application, if I could ask you to look at Figure 6, which is at Supplemental Tab 7, page 131. So you see, as my learned friend explained, you have a series of inputs, 1 down to the letter N, input 1, input 2 down to input N. And you have the outputs O1, O2 down to output N. And he was postulating, and this is one way you can do this, saying you have 10 inputs about tonality. 10, I'm going to have 10 for tonality, 10 for rhythm, 10 for timbre, for example. And those collectively form I1 down to IN. And you might have, say, N in this case might be 60 in total. When you get your outputs, the value of M could be something completely different. It could be 50 or 100 or 20. So there's no one-to-one concordance between inputs and outputs at all. The numbers usually will be different. It's possible.
So I'm a bit puzzled by what you mean about outputs there, because what we have here is a summation process with a single output.
No, in here you have M total output, M total outputs.
Sorry, we have inputs of x1, x2, x3, xr.
Sorry, my lord, I apologise. I'm looking on the right-hand side. The left-hand side is showing the functionality of a single neuron, and my lord is absolutely right. I'm looking on the right-hand side to look at the collection of neurons in the system as a whole.
Right.
And you can have up to n inputs. So you might have 10 inputs which describe the tonality features extracted from this track. And so you have numerical inputs which, in the way it does, and I don't know the detail, describe tonality in 10 numbers. And then you might have 10 more about rhythm, etc. So you have all these input numbers. And I'm going to come through the middle stages in a moment, but at the output for each song, you get a vector, so a string of numbers, which is, in this case, m numbers long.
Indeed.
Okay. But m and n, there's no reason to presuppose they should be the same at all.
Oh, indeed. Sorry, I've not understood the point you're making, but that I don't.
No, my lord, I apologise. You thought I was pointing to a different diagram, so the faults were mine. Now, and the other thing to note about this is, when you look at, for example, the first layer, the first internal layer, hidden layer, you can see that if one takes the first 10 nodes as being tonality, you see that all of those nodes feed through to all of the nodes in the first layer. This is what's known as a completely connected structure. Sometimes there's some degree of disconnect, or as we'll come on to see, things can be deleted during training. But broadly, each node feeds to everything, and then they all feed to each other as you go through. And at the bottom layer, all the nodes feed to each of the output nodes. So what you see from that is there's no siloing of all the tonality inputs to form a bunch of tonality outputs. What happens is the outputs are all a kind of blend of all the inputs. Now all the outputs are different, and they blend things in different ways, and they have regard to different features of the music and give different weights. So it's very, very complicated, but you can't say, even though you might have tonality inputs and rhythm inputs, you can't say that any of the outputs is a tonality output. It's just an output which has some regard to all these features according to all the individual weights and biases that interact with that final output node.
Yes, so the output is just a vector.
The output is just a vector. And sorry, maybe this is my fault. I thought my lord was suggesting that some of the outputs would have been a tonality output and some would have been a rhythm output.
No, it's as I understand it, you'll correct me if I've misunderstood, it's a vector in property space.
Yes, it is. It is.
But just to make sure I've understood this, because I'm not sure I do now, it's a vector in property space where the axes in property space are not properties, specifically like beats per minute is one axis and something. That's the point. And the dimensions of the vector of the property space is m, not n.
Yes, indeed.
And m, you could imagine putting in 100 physical properties at the beginning, n, and actually only having four dimensions at the end. Say, I mean, I'm not saying
sure.
Whether you would do that, I don't know, but you could imagine that would be consistent.
Yeah. You could do. You wouldn't. I think in this case you wouldn't, but you can contemplate cases where that could happen.
The point is, m and n don't relate to each other.
No, they don't. It would be coincidence if they were the same. Then when one comes to training, in training, you take a pair of tracks in your training data set, each of which is tagged with its own semantic description. As we've already discussed, you've run the text through the semantic processor and determined a scalar distance between the two vectors. And then you run each track through the property ANN and obtain two vectors and again determine the scalar distance between them, the dimensionless distance between them.
Sorry, just run that past me again. Exactly the same words will do. You run each track through the property ANN and then...
And, sorry, I didn't have those words written down, but you run each track through the property ANN and you obtain two vectors and you calculate the scalar distance between those two vectors, the dimensionless scalar distance. And there then follows what the judge in paragraphs, sorry, this can go away if that's convenient. What then followed in the judgment in 10 and 11 is the significant trick of the invention. And as the judge describes there, you train the physical ANN to converge the distances for each pair in semantic space with the differences between them in property space. So I think I said that the wrong way around. Forgive me. You train the property ANN to converge the distances in property space so they reflect the differences in semantic space.
And that's done through the backpropagation.
That's done through backpropagation, etc.
Yeah.
But it's only the property ANN which is changed in this process because that's the one that's being trained.
So is it right to say that the property ANN experiences, as it were, from its point of view, experiences two rounds of training? The property ANN starts as just an ANN, a naive ANN, and it's trained with properties, and that turns it into a property ANN.
No,
then,
sorry, I shouldn't interrupt.
Okay.
No, the properties are extracted just by standard property extraction tools that exist at the priority date. So your rhythm, tonality, term, you can use a Mel spectrograph is one of the things it talks about. But those are extracted using standard techniques at the priority date.
Yeah.
And those extracted physical features are fed into the ANN. And the ANN then spits out a number. And it's trained to spit out, it's trained in pairs so that the numbers it spits out for tracks which are given tagged with similar semantic descriptions end up close together, and those which are tagged with dissimilar semantic descriptions end up far apart in the embedding space.
Right. So in paragraph 9, when the judge says, in paragraph 9 in particular, when the judge says, at the same time, the two tracks are analysed in another ANN, and that's the thing we've been calling the property ANN, or what I've described as its physical properties. And then he says, that analysis produces vectors in a notional property space. That's not actually the same, that's not actually a prior step to what's happening in 10. It's part of what's happening in 10.
Indeed. So in a sense, I think the confusion might arise because the property vectors in the property embedding space don't really tell you anything understandable about the physical properties that were put in the top. What it is it's doing an analysis of those properties to generate vectors. The consequence of that physical analysis is that things which in fact are semantically similar are embedded close together and vice versa. Yes.
So it isn't just purely as a matter of grammar, and I'm not going to criticise the judge, but although paragraph 9 says that something is produced in paragraph 9 and then there's a next step, that's not quite the right way of thinking about it.
I think you're right, my lord. You might have written the other way around, as it were, and that the training occurs so that the ANN of paragraph 9 can produce the property vector, which has the property of embedding things in the way that the invention claims.
Yeah, but how does the ANN learn to produce the first property vector?
So essentially, with any ANN, you set it up, and the first vector you produce will be virtually arbitrary. So if I'm doing an ANN in a completely different field, any ANN in any field, the first time I run something through there, I'll get a result that's effectively arbitrary. And then the backpropagation system will say, well, the answer should have been 3. You've given an answer of carrots, or 20. We're going to fiddle with the structure of the ANN so that, actually you'd give a 19 this time. And then the next time it runs through, it gets an answer of 73 and it should have got 2, and it fiddles it so the 2 becomes a 3. And that's why you need, and over millions, often millions and millions of iterations, a structure internally develops which has the property of doing the thing you want to do, be it identifying pictures on the internet. Here it's generating, here it's, well, we know what's going on here. In other cases, natural language processing, working out how to look at the words that appear in bits of text and actually associate ones that in fact have a similar content. But at the start, it's just arbitrary, and then it slowly converges. And that's why these things take millions of runs through, typically for anyone of any complexity, to train.
All right, thank you.
So calling it property space is a function of the inputs, or the outputs.
But as we understand, the consequence of that is that by the analysis of the physical properties of the track, the ANN can identify and recommend other properties which, from an analysis of the physical properties of those other tracks, it knows will in fact be semantically similar. And it can do that even if none of the tracks I just referred to in use, this is, ever had a semantic tag associated with them. And there's 4 further points to note here. The first is that the process we've described doesn't converge the semantic space and the property space themselves. The physical property space doesn't take on the same shape or form as the semantic space. And you can see this most easily from the fact that they may well have a completely different number of dimensions. And you'll recall what's used is the scalar, the directionless differences between the pairs of tracks as well. And that's another reason why you can see that they're not converging shape. They're using this as a tool for changing the physical embedding space, but it doesn't then just copy the semantic space. And the second, I hope this will be completely apparent, but the ANN is not making itself any musical or taste-based judgment. The analysis is based only on the physical properties. And indeed, as my Lord Justice Birss noted yesterday, and I've stressed this morning, even the semantic analysis of the texts in training is just an analysis, a mechanical analysis as words. Even the semantic analysis doesn't actually have any understanding of the meaning of those words. It's purely mechanical. The ANN is not expressing an opinion on the music or understanding the nature of the music at all. The third point is that the resulting ANN in this training process, or an ANN in any training process, has a structure which is different from any other ANN. There's a different structure of links and nodes and weights and biases, and it's that new composite structure which enables it to do what it's been trained to do. As Professor Pardo says, a new ANN is a new machine with a new and improved structure. He says each iteration of training produces a new machine with a new structure. And finally, the fourth point, which is that in the ANN, I'm going to say the human rather than get into debate about programmers or not programmers or scientists, the human does not prescribe how it is that the ANN analyzes the physical characteristics so that musical simile tracks end up closely embedded in the property space. That is something that ANN has to determine for itself from the data. And my lady, my lords, to understand the reason for that, most simply, it's not known to any human how the physical sounds of a song or an analysis of the extracted physical features of a song actually relate to its semantic nature. No one, at least as far as we are aware, and this case has been prosecuted all over the world, has ever worked out how to do that themselves. But by using an invention like this, you can make a machine which can be produced to do the task nonetheless. So no you couldn't write a computer program to do this. Let's say a classic computer program to avoid a computer program to do this, because the programmer wouldn't even know how to start to address the problem or to write the solution to it. It's what is referred to in the papers as the intractable problem, and it's a key distinction between what ANNs do and what normal computer programs do. They're capable of doing this. Now I was going to move on, subject to any questions, to the contribution.
Just hold a moment.
If I can take you to the hearing officer's decision where he sets this out, because there are, the main paragraph is set out in the judgment. There's a few other bits I would like to show to my lady, my lords, if I may. So the decision is in supplemental tab 6, and I would like to invite the court, if I could, to read paragraphs 53 and 54 on page 117. So 53 sets out what we submitted was the contribution. 54, well, and let me just point out a few things. It says the invention of the application ANN-based system for providing improved file recommendations. That's its overall job. The invention may be hardware or software implemented, so that's talking about the manner of its implementation. There is then the section about the fundamental insight, and that is summarising the main point of inventive step. At least the main point that's come up in these, if there was other prior art, another point might arise. But for present purposes, that is summarising the main point of the inventive step. And that then goes down to 5 lines in the bottom. Once trained, the ANN can be used to identify swiftly and accurately files from a database which corresponds semantically to a target file, and to provide, again, swiftly and accurately, file recommendations to a user device over a communication network. In 54, the hearing officer says that's a fair way of putting the contribution. The reference to accuracy captures that the system is better at identifying and recommending files to the user based on their semantic similarity.
And as I understand it, you don't quarrel with that as a finding.
It is better because the analysis produces files which are then recommended, and the benefit of the file that's recommended is that it is it's a file that the user is more likely to enjoy or to enjoy more.
Sorry, if you don't mind, I'd like to proceed in stages. So at 53, the hearing officer has quoted, and I assume accurately, your submission. Yes?
Indeed.
In paragraph 54, he accepts your submission, but that's a fair way to put the contribution. So that sentence is in your favour. So what I'm interested in is what he says in the next sentence. The reference to accuracy captures that the system is better at identifying and recommending files to the user based on their semantic similarity. Now, do you accept or do you dispute that second sentence?
I would explain the second sentence, which is the
system. It sounds like you don't accept it.
Well, I think I do, but I think it needs unpicking before to make clear. The invention works by an analysis of the physical properties in use, that is, only. The benefit of the invention is that the files that are recommended are better in that they are semantically better, as it were. And you can see that at the end of 48 as well.
Now, would you accept that the word semantically can be replaced by the word aesthetic?
I would accept it would be certainly you could musically you could substitute it for aesthetically. I think. Can I say yes unless I come back to my lord and say no later?
Certainly. Thank you.
But my lord, perhaps what one would do is if one looks at 47 and 48, that really summarises how I was unpicking the statement that my lord was asking me about in 54.
Well, in 48, the hearing officer says it advantageously reflects the subjective emotional perception of similarity between files. So, again, as I understand it, you accept that when the hearing officer uses the words subjective or emotional, one could equally use the word aesthetic.
For the benefit of the invention, yes.
Thank you.
Obviously, I think the point we'll get to is that doesn't make the invention or any aspect of it an aesthetic thing in itself.
Indeed.
And although I slightly butchered it off the top of my head, that's what the exclusion is about. But we'll come on to that, I'm sure, my lord. The other thing I just wanted to show my lady and my lords is when the hearing officer accepts that it's that the swiftly and accurately benefit, one can see that in paragraph 49. And in particular, one sees about halfway through, towards the end, and the final sentence, the claimed invention is said to be simpler and faster, this is in the closest prior art, the only prior art cited. As a result, I'm willing to accept these alleged differences and advantages over the prior art. The reason I flag that is my learned friend talked a lot about puff and benefits. Now, my Lord Justice Birss raised a very perceptive question, and also my Lord Justice Arnold, as to whether the benefit matters. But here, there is a finding of that benefit as well. So we have 3 benefits. Now, there's one other point. So sorry, just to be clear, when my learned friend made those submissions about benefits, those aren't open to him because the hearing officer has found there are the benefits, in fact, insofar as that matters. The other point I wanted to address was my learned friend submitted to the court when looking at what I'm going to call the protecting kids type argument, the message. He said that the only contribution I say there is in the claim was the message. That is wrong. The contribution of the claim is an ANN-based system, and we see from the claim the system involves all sorts of other bits of hardware. It's a system. That system has certain characteristics. It has certain benefits. Now, the focus of the argument in respect of the protecting kids point, the focus is on the message that's sent. What I don't want it to be said is that more generally, I accept that that is the only part of the contribution.
Sorry, Mr. Jacksfield, you used, with some emphasis, the word system in that submission, which I find very distracting in this context, because when we deal with patent claims, we're talking about products or processes, or products or methods. And to my understanding, system is a synonym for product.
You're right. You're absolutely right to pick me up on that, my lord. Claim 1 is a system claim.
Well, it's a product by process claim, as you told us earlier, which is problematic, as we've already been over a couple of times, because it's trying to be a hybrid type of claim.
Well, in a sense, but it does contain the product by process ANN, and that is a thing, and it also contains the database, the network, the user device, etc.
This is why it's simpler to focus on claim 4, which is a pure method claim, and therefore we know what we're talking about.
Well, it's a sort of hybrid still, because it starts a method for providing a semantic relevant file recommendations in a system, including. So it's a method for using a system, which is how I phrased
A
it.
method
in my
for
submissions.
using a product.
Yes, indeed, more accurately, my lord. Yeah. But what I wanted to say is, whilst the focus when we're looking at the message, whilst the focus is on the message, obviously, I don't want it to be thought for a moment from my learned friend submission that I accept that as the only contribution. The contribution is much broader than that. And just while I'm here, if I can just pick up the point that my Lord Justice Arnold has raised about what submissions were advanced in front of the hearing officer. The short point is the case advanced in front of the hearing officer was the same as the case advanced in front of Mr. Justice Mann, as also advanced in front of this court. In basic substance, and obviously things will have sharpened and evolved slightly. But in terms of the question of did we run the point in front of the hearing officer, that even if we were wrong on our other submissions, that we obtained a technical effect by reference to the sending of the message, we did absolutely run that, and you see that recorded in 71 to 73 of the hearing officer's decision. Now, he rejected it, and obviously say he was wrong to reject it, but it was run, and it was run on, so that it was run on the basis that I ran it before my lords and my lady, which is, even if I'm wrong on all my other arguments, this is a sufficient technical effect to get over the claim exactly as per, as you see, the discussion in Gem Star and Protecting Kids.
Thank you.
And my Lord, Lord Justice Arnold referred to at times the fact that the hearing officer kept focusing on the key insight, I think it's phrased. Well, he kept doing that, but in my submission, that was because he was wrong to do that. That was why he was in error, as the judge accepted, because that was to seek to focus only on the invented step, the contribution approach, rather than looking at the contribution as a whole. So you've got to be careful about reading too much into the way this judgment is written, because we say...
Well, I think, to be fair to the hearing officer, I'd overlooked what he'd said in 71 to 73, which you've just pointed out.
My lord, my lady, my lords, I'd like to move on if I may.
Can I just say this? It was clear to me, at least, that you were taking issue with a great deal that was being said yesterday, certainly as to technology. So it is important that the court properly understands what it is you're saying.
I'm grateful, but I'm also aware it's important for me to finish. So I was, subject to any further questions, going to move on to the technical background, because here, in my learned friend's submissions on this subject, he sought to give a particular, and we say entirely incorrect, view of what an ANN is, and how he says it can be carved up into a general purpose structure, and then weights and biases, which he calls the program. But before doing so, I think it might be helpful to take a quick detour via the Act so we know what the target is. The statute, I wasn't going to get it out, but my lady of sister can.
Well, I have read it.
Indeed. And my propositions are fairly straightforward as well, I hope. But section 1.1 says a patent may be granted for an invention in respect of which certain conditions are satisfied, for an invention. And the fourth of these is that the invention is not excluded by subsection 2, amongst other things. And subsection 2 lists out the prohibitions with the as such proviso at the end. Section 125 says that, at least in general, an invention is that which is stipulated in the claims of the patent or the patent application. And this is all obvious and very simple, but it makes an important point, which one also sees in all the cases we'll look at, which is critical to focus on the invention itself. In other words, that which is claimed. And the importance of that is one has to have regard to the invention at the level of generality at which it's claimed. In this case, the invention is to a system or method of using a system, so a product or method of using a product, containing, amongst other things, the ANN. And it's common ground that an ANN is a structure of nodes and links and weights and biases which achieve a particular function. In a hardware, it's just a box of electronics. You saw that in the judgment at 14 no doubt. But as the judge held in 18 and 53, in a software ANN, the same structure is emulated as if it was a hardware ANN. And this is really the point about software and hardware ANNs, which is just that at the level of generality of the invention, they're the same thing, this structure of links and nodes and weights and biases. And sure, they may be implemented in particular ways, but that's just the question of implementation. And we'll come on to the Vicom case. But that states in a passage that's widely been cited by, in this jurisdiction, including by the Court of Appeal on several occasions, it says it's wrong to distinguish between embodiments carried out in hardware or in software, since those do not change the essential nature of the invention. And it also says that in general, an invention which is otherwise patentable is not excluded from patentability by the mere fact that modern technical means in the form of a computer are used for its implementation.
So you would accept, I take it, on that basis, that we could ignore the fact that there could be a hardware implementation of this. We could treat this as if it's a claim purely to a software emulation.
I wouldn't accept that, my lord. But let me explain why.
You just told us that it's immaterial to distinguish between hardware and software.
Sure. I certainly accept, let me break that into two if I may. I certainly accept that a claim which is bad in half is bad.
Right.
So it's not, just to be clear, an argument that some of it may be good so it can have the whole claim. Obviously that would be wrong. The point is just that by
your clients wouldn't want a claim limited purely to hardware anyway.
Well, a broader claim is better, but you have to bear in mind there is an element of a test case about this case as well, so you shouldn't draw too many inferences about that kind of thing.
All right, but you don't have that as a fallback position.
No, we don't. The point about the hardware implementation is just that it's sometimes quite a convenient way of actually thinking about what an ANN itself is. That's really the point about the hardware. And really the point then is just to highlight that an ANN, as claimed, is this structure of links and nodes and weights and biases that function together as an overall machine to achieve a particular end. But it is no more than that. So that's my... yeah. I suppose the other way of looking at it, though, is the Vicom way, which is if a hardware ANN is claimable, then the fact that the same invention might also be implementable as software in circumstances where it's the same thing just emulated on a software platform using modern technical means of a computer, then we should be able to have both halves of the claim. So again, that's just another facet of the fact that the hardware implementation is informative of the nature of the software emulation. But I do want to flag both of those, and that's why I referred to that passage in Vicom just a moment ago. So the second preliminary point is the construction of the Act. Now, yesterday there was a discussion over what a computer was. My Lord Justice Birss raised questions of analog computers, which gave me some happy Googling overnight. I'm afraid I'm not that much the wiser about those. And I can see in this case, you could have an interesting debate about what the wider edges of a computer is or might be. But what is critical to this case is what a program for a computer is. The reason I say that is because if you look at some of the wider types of things that are sometimes described as computers, you could easily classify those as computers that don't in fact have a computer program. And you then end up chasing one's tail, which is why I think one should in fact focus on the statutory language of what is a program for a computer. And the meaning of program for a computer was, at least I thought until yesterday, common ground. The judge addressed this, if I may take 36 of the judgment. Where he sets out various definitions, 4 definitions of a program for a computer, or a computer program. And each of those is in broad terms,
I'm sorry, did you say paragraph 6?
36,
36.
my lord. I apologise. I think it's page 98 of the bundle.
Right.
He sets out 4 definitions, each of which is broadly a sequence or set of instructions for a computer to cause it to do a particular thing. And a note underneath that the controller didn't quibble with any of those definitions. She accepted those at the last hearing. And that's not been appealed. And indeed, in my learned friend's skeleton at 63.2, they cite some of those definitions.
Yes, and Mr. Nicholson's submission to us yesterday was identical. And you'll recall my Lord Justice Birss asked the question whether there was any magic in the word instructions. Mr. Nicholson's answer to that was no. I asked the same question of you.
Sure, so yes, and can I take that into office in stages? My learned friend on his feet yesterday sought, in fact, to move away from that. He's tried to move to a much broader definition. He said on a couple of occasions, input, mathematical calculation, output, which he was trying to use as a summary for what he said a computer program was or represented. Now, if that's actually his statement as to what the statute means, then obviously I would dispute that. The statute, we say, is common ground, at least ought to be, is about a set of instructions that inform a computer or make a computer do a particular thing. And when you look at the word instructions, which my Lord Justice Birss, as you say, raised, we say that's freighted with 2 elements. Firstly, it carries an element of imperative or command, right? You're telling A is telling B to do something. And to go ahead, the distinction that we're going to come to is there's a difference between that and a component that just does something which happens to have a downstream effect on something else. I'll come on to that, my lord.
Well, really? I mean, look at the Macmillan definition. A set of instructions stored inside a computer that allows the user to do a particular thing, for example, produce a document or play a game.
Sure, but it's still a set of instructions for a computer. So the second half of that tells you what the computer program does, but the key bit, which you see throughout all of these definitions, is that it's about a set of instructions which tell a computer what to do. And you'll recall that in Gale, that was decomposed perhaps slightly more accurately to be, when one looks at the word computer, to actually be a set of instructions for the CPU, or it could be multiple CPUs nowadays. But that, we submit, is what the legislature had in mind for this exclusion.
On what basis do you say that, when the legislature was legislating in the early 1970s?
Because, well, what we say
These
is...
are not definitions from the early 1970s, are they?
Sure, that's true. That is true. In a sense, that doesn't matter.
Just to complete the thought, forgive me for mentioning analog computers, but the relevance of it is that the way you program an analog computer is in an analog fashion. In other words, you can turn a dial, you can turn a resistor, you can take a dial and turn it round to a certain thing, you can tune a capacitor. That's how you program an analog computer.
Well,
the reason it's relevant is it looks an awful lot like what you're describing is done in setting the weights of a neuron.
So I think...
You would say, as I understand your submission that you've just made, that sort of thing is not a set of instructions.
Well, I would. I think I would decompose that slightly, which is... and this is why I was trying to get the bottom of what was going on with these things. Because you can have... My learned friend, take a different example, mentions ROM and says ROM is a hard one.
But you're always thinking digital, Mr. Jackson.
Indeed, I am. So I'm just trying to work to the point, and partly because I'm slightly floundering because I haven't been able to pin down a proper understanding of the analog computer. The fact that something is in hardware, it's still a series of instructions. If it's on a floppy disk, if it's in ROM, it's still a series of instructions for the CPU to tell it what to do. When one comes to an analog system, I can at least conceive of 2 types of systems. One of them is where you have hardware things, which actually form instructions which are then enacted upon by something with processing power. And that is just another way of writing down instructions which are then acted on by the computer thinking part itself. You could have another analog computer where you alter components, but it's just altering electrical components which produce a machine that achieves a function. I'm going to come on to develop this argument very shortly. And in that case, you might have an analog computer, but you don't have, we would submit, anything that constitutes the instructions that form a computer program. Now, I find it hard to go any further with the analog computer, which I'm afraid I don't have the knowledge to do that, but we're going to come on to talk about things like a voltmeter. A voltmeter has a bunch of electronics, which the components in which, and the values of components in which, are chosen, sorry, I'm actually going to come to an ohm meter, but are chosen to achieve a function. Or if you look at a hardwired filter in a mobile phone, and again, I'll come on to this, you have a cascade of components of a pretty standard form, which are then given through, usually through an iterative design process, particular values, to achieve the filtering function they achieve. Now, I would say none of those, even though you've got a bunch of components chosen with particular values to achieve a particular effect, none of those are instructions for a computer. They're just a machine that does something. And one has to be careful about eliding what something does and whether there's a computer program within it. I'm going to come off all this. But our submission here is that this is the definition. It's a set of instructions for a computer or a CPU to command us to do something.
So I interrupted you when you were telling us there were two elements to the word instruction.
Ah.
Firstly, it was imperative or a command. What was the second element?
So the second was human involvement, programmer writing the program. So within it, it would have...
Well, really? What if you have a computer program to write another computer program? You're telling us that the second computer program is not a computer program?
Well, if you have a compiler, we say is just translating. That's not a problem. A computer program to write a computer program,
which have been well known for a long, long
I
time.
think you need to look up again, Mr. Changsfield. There's impure code, code which writes code.
Code which writes code. Well, that's why I don't have biologists for these cases. My lord, sorry, I hadn't considered impure code. It's the kind of thing I wouldn't Google freely at home. You may have, it may be then, I'd have to think about that. But even in that case, you're right. Well, can I think about that over the shorter journeys? I was now going to turn to the technical background proper. As we've... sorry, yesterday my learned friend, as I said, my learned friend sought to be very careful.
Well, I'm sorry to interrupt you,
sorry.
But while we're on this question, can I ask you the same question that I asked Mr. Nicholson, which is, given that there's no definition of either computer or program in the Act, as I understand it, you make the same submission as Mr. Nicholson, which is one gives it its ordinary meaning, and you say, look at the dictionary.
Well, I say give it the dictionary meaning, sure.
So you're not advocating any special meaning in the context of the Act.
Well, I'm advocating this meaning, my lord, which I think the answer is yes.
I don't think any of these dictionary definitions refers to the Patents Act 1977.
Indeed.
So you're not saying that there's a special meaning in the context of the Patents Act 1977, which is different to the dictionary meaning.
Correct.
Right. Next, do you accept, and I think, like Mr. Nicholson, this is implicit in what you've said already, that we should apply an always speaking interpretation. That is to say, we don't interpret the word program as it was understood in 1973, given that that's the source date. We interpret it in the light of contemporary technology.
I would say yes to that, but one still has to end up with something which is a set of instructions to make a computer do a thing. So, in a sense, I would say yes to my lord, but that doesn't mean you can then just throw away the definition, you're still looking for a series or a set of instructions to make a computer to do a thing.
Yeah. Don't you have to know what a computer is before you can answer that question?
You do need to know what a computer is, but what looking at the wording of the Act there directly focuses on is you don't have to worry about getting into arguments about things which could potentially be described as computers, but for which there is no set of instructions or program. A sextant. I'm going to mention a sextant in a few minutes.
So what is it? What is the do you have a definition for a computer? I mean, the definition of a computer which Mr. Nicholson put to us, and forgive me if I'm doing this on memory, was some words to the effect of something which processes data.
Yes, and I'm going to submit to my Lord that's obviously much too broad, because a sextant does that, for example, and nobody in their right mind would call that a computer. That takes in an input by reference to moving the arms. It performs something that if one wanted to, one could describe as a mathematical calculation, and it gives you an output. And that's the way my learned friend sought to characterise that part of his submission. But we say nobody in their right mind would describe a sextant as a computer. And certainly, even if they did, it's not a computer that has a program. But
what about an old-fashioned mechanical adding machine?
An old-fashioned
mechanical adding machine.
So I would say that's not a computer, my lord. Well, it depends how the adding machine works, in a sense.
They use conchs and wheels.
Probably that would just be a mechanical. That would just be a mechanical machine. It would just be a machine which has a function, which is a function that can also be replicated on what you would call a computer. We would say.
Forgive me for asking this question, Mr. Shaxfield. Do you know who Annie Jump Cannon was? Annie Jump Cannon, let me tell you, was one of the Harvard computers. And she, needless to say, is a person. And she is famous in astrophysics for the way we classify the spectra of stars. But her title, her job, was to be a computer.
Sure, I do. Now you describe, I do know. I wouldn't have known the name. My apologies to her, but I do know who you're talking about, my lord. I think there's a book or a film about her recently.
Lots of things.
Yes, indeed. But she is one who computes. I would accept that. But certainly the Act doesn't have that in mind.
No.
In paragraph 39, the judge referred to a definition that he found from the Oxford English Dictionary. And we would say a computer is certainly going to be a device which performs, it's a device which performs calculations. But the important thing about the definition he has in there is it's processing it in accordance with variable procedure instructions, programs, or software. So we would say that the Act, and there is a circularity here, which is why I pause. The Act, we say, contemplates computers being things that execute serial logical instructions.
So as I understand it, you accept that this is an appropriate definition of computer?
Can I have a look at this over the short adjournment, my lord? I don't want to come back and find that there's a point of detail I want to quibble on or not. But the thrust of our submission is certainly going to be, it's an electronic device for executing what you'd normally call serial computer instructions using processor hardware. So that's a CPU. A CPU is what Gail referred to.
So you seem to be inserting words into the definition, because I don't see the word serial and I don't see CPU.
Sure. Well, my lord, I think rather than trying to draft on my feet, if I could do this over lunch, that might be a quicker way of proceeding.
Okay.
So with that, may I go to the technical background issues? As I was saying, my learned friend yesterday sought to give a very carefully curated view of what an ANN is. And he designed his submissions to support his proposition that an ANN can be divided into a general purpose structure of nodes and links and a program of weights and biases applied to it. And he does that for obvious reasons, because he's trying to find a program for a computer within an ANN. There's a great pains to give the impression that you could separate the links and nodes from the weights and biases. And we say that is wrong. An ANN is a machine, it's an electronic machine with an overall structure which, as a composite whole, provides a function. Now, the first thing I'd like to draw your attention to, my lady and my lords, which my learned friend didn't mention, is that during training, the structure of the links and nodes themselves may be changed. Professor Pardo, it's a very short bit of evidence, but if I can take Professor Pardo's report, paragraph 39, it's in supplemental 9, page 216. Bundle page 216. Sorry, 216, but
216,
supplemental
my
9,
apologies.
page 216.
No, I'm sorry,
my
I had the wrong page.
It's just this short paragraph 39. Some training measurements have the potential to redefine the topology of a neural network. For example, in addition to modifying weights and biases, neurons can be removed, pruned from the hidden layers. And in the art, there's lots of other techniques involved, trimming links and things like that. One of the cases that my learned friend refers to is about trimming links out. So what this underlines is it's just not as simple as my learned friend seeks to portray it. In training, the nodes themselves, and therefore the links too, may be pruned. So, for example,
But they may not be.
They may not be.
It's an option.
It's an option, but what it tells you is about the nature of ANNs themselves. Because in training, some ANNs might trim nodes and alter links and biases accordingly. In another ANN, it might not trim the nodes, or it might trim different nodes, and accordingly different weights and biases will evolve.
Just to be clear, some, for what it's worth, and I don't see why this matters, but some ANNs just can't do that.
It may depend how you set your, sure, it depends how you set your training regimen up. But what it tells you is, the point of it, my lord, is not that every ANN can do it, but it tells you about the nature of ANNs, which is it's not fair to say you start with a generic set of links and nodes and you apply to it a program of weights and biases, because the whole thing is interlinked. Training might change the links and nodes, not just the weights and biases.
Okay.
And if you trim out weights and nodes, you get different weights and biases. It's just a composite whole, again, and that's the point I'm trying to get.
When you're training an ANN, there is by some means or other, and it's not voodoo, it's just electronics, a memory. The ANN has to remember in some way all of the weights, biases, and if it has prunable links, that all has to be remembered, because the ANN, after you've trained it, remembers what you did before. That's the whole point. So whether it's digital memory or it's some analog memory, I don't know what, doesn't really matter. There is a storing of memory in the ANN as you train it. That's
So
right, isn't it?
during training, a computer program may be involved to systems training process.
About a computer program. Somehow or other, the thing has to be, you have to be able to, the ANN after you've run it once is different. And you haven't taken your screwdriver out and started fiddling with anything. So somehow or other, it's remembering what's happened.
So that can be done, as I understand it, purely
It doesn't matter how it's
mechanically.
done. That's true. The level of
It is
stopping
true.
at the level of generality, there is a way in which it's remembered.
Yes.
It probably varies in different machines.
Yes, it's just the use of the word memory. That might be remembered because you can have,
Well, are you happy with remember?
well, it can be hard code, it can be hardwired, because you can just have a particular a variable resistor, for want of a bit more sophisticated, but you can just have a hard device that has a particular value, and it obviously has that value.
But if it has a particular value, then when you've trained it, it will still have the same value.
Yes, indeed. I'm just saying it's not using a sort of digital memory in that circumstance.
No,
That's
but
the
there's
input.
still a memory, so
Yes.
the hardwired resistor isn't going to change anything when you run it through the training program. But somewhere in an ANN, there is something which changes,
Sure.
and that change is persistent over time.
Sure. Absolutely. Yeah. So it was only word memory. So yes, my lord, that's
What do
absolutely
you
right.
call it?
Well, I was worried. I wouldn't. It was lest it be thought that that's a discussion about digital memory. But no, I take my lord's point completely. And what's more, you can print out an ANN. So if you have an ANN that's a software emulation, you can print it out, and it will print out the links and the nodes and the weights and the biases. If you have a hardware one, then you can also print out the links, nodes, and weights and biases. But my assumption is those will be stored by the machine that has the program that's been involved in the training process. Okay, my second point here, and it's obviously related, is it's simply not possible to have an ANN which doesn't have all the features of links and notes and weights and biases. Every link must have a value, and every node must have a value, since it's inherent in just being a link and a node. And that's quite unlike a computer, where you can download or remove programs at will and the computer remains. And again, the submission I'm making is the features of an ANN are an intertwined whole. They are not divisible in the way my learned friend seeks to do it. Because the function of the ANN is determined not by its weights and its bias, but the combination of the weights and the bias and the links and the nodes. And that whole is, well, that's an individual.
Once you've trained an ANN, so you start with a naive ANN where all the links, biases and things are, I'm going to use the word trivial to try and characterize what we mean by a naive one. So they still exist. You made the point they're still there. They still exist. You then train it, and you finish the training process, and you now have new weights, biases, links, and everything else, and you can, as you said, print that off, by which you mean you could effectively create a paper record of this stuff which is somehow remembered by the system. And is Mr. Nicholson right that not only can you do that, but you can then use this, I'm going to say information because I can't think of another word for it, whether it's in electronic form or in paper form, I don't care, to configure, and I'm deliberately using the word configure to avoid an argument, a fresh ANN, which is a different object from the previous one, to make copies of the trained ANN that you made.
Well, what you would need to do is take...
First of all, is that right? Can you do that? Mr. Nicholson said you could. Sounded like he was right, but...
You can do that so long as you've taken an exact carbon copy, not only the links and nodes, but also the weights and biases.
Yes, yes.
And so it's the same. So I'm making the same point again, which is you have to take the composite whole.
Yeah. Well, you say you have to take the composite whole. You've got a hardware ANN, say, which is an actual object. You can extract from that object information, which is the whole of the things you can extract, and you can use that whole extracted information to make a copy of the physical object from another ANN, which you then apply what you've extracted to that second ANN. So you end up with now two ANNs where you only had one before, and they both represent the same result of the training.
Yes, but
that's right.
That is right. But what you have to do to do that process, you break it down a bit more, is you have to take a copy of the links and nodes to make those, and then you add the weights and biases on them. So it's not
copy all the stuff you need to copy.
You need to copy all the stuff.
It's all copyable.
Yeah, and it just all goes as a composite whole. That's the point. And so when my point is this, which is my learned friend has to find a computer program within this. So he tries to divide links and nodes as being hardware or the computer, and weights and biases being the program. My submission is that's just an artificial division between the things because it functions as an electronic composite whole. Now, just related to that, then, Michael, there's no evidence that anyone other than the UKIPO in this court has ever described or viewed an ANN in the way that the UKIPO does. In his report, in this case, Professor Pardo describes it as a machine, and saying after each iteration of training it's a new and better machine. That's his 24. He doesn't describe it as an improved program for the machine. And nor does he anywhere suggest that an ANN can be described as having a general purpose computing part with a program overlaid. The whole tenor of his evidence is that ANN is a machine as a composite whole. I'm sure my lady Maybe we have the OECD definition of an AI, which is a machine-based system. That's the definition that's taken into EU AI Act as well. And the UKIPO doesn't cite anybody else who says that the proper way of understanding an ANN is as a computer with a program subdivided as they submit. Now, my submission, that's quite important, actually. This is a case in which the UKIPO is advancing a completely new argument, indeed a complete reversal of their previous concession. One might have expected them, if they existed, to come up with articles of the like explaining the operation of an ANN in the terms they now urge on the court, to explain and justify their marked reversal in position. But they don't have anything. They're not scared of handouts. But on this critical point, they have nothing. And we do play that in aid. Because what we say is, this was a view, not only is there a lack of support for this new point, but this was not a view that was espoused by the hearing officer.
I may be mistaken, but I thought two of the EPO authorities described it in this way. I may be wrong about that, but that was my recollection.
Right, I'm afraid I'll have to think about that as well, Mann.
All right.
But it wasn't the view the UKIPO took in front of Mr. Just Mann. Well, they took the opposite position, and no doubt they took that position advisedly and after careful consideration. But what we submit that indicates is that it's a good indicator that analysis is wrong, and that that's not how scientists in the real world understand the operation of an ANN at all. And we also make this submission, which I think is our fifth submission. The argument of the UKO risks confusing the function of a device and whether there is a computer program in that device. And the point is this: the fact a device is able to do something which could be described, if you wish to, mathematically, and then outputting a result, does not mean it's a computer, or more relevantly, using a computer program to do so. As I said, my learned friend, it was at T170, he said, input, you have inputs, mathematical processing, outputs. You can create an electronic device, the function of which is to perform a particular process, which process could be described mathematically, and to output an answer. You can make a purely electronic device to do that. And you could write a computer program to instruct a computer to perform the same overall process, even in largely the same way. But that doesn't make the electronic device, in our submission, a computer or a program for a computer. It's just that different technical approaches are being taken to achieve the same functionality. So take a simple example. I mentioned the ohm meter already, but as I said earlier, this is a collection of simple electronic components. It takes an input, it performs an analysis which you could describe mathematically if you wish to do so, and it gives you an output, which is that a needle moves on the dial. And the function it performs is a result of the particular values ascribed to the components within it. So it takes inputs, it does what you can describe as a mathematical process, and it outputs it. Now, in my learned friend's approach, a basic ohm meter would be a computer, or have a computer program within the Act. And we just submit that's not the kind of thing the legislature had in mind at all. Now, the structure of an ANN is much more complex, and the analysis it performs is much more involved. But there's no, in our submission, qualitative difference between those two examples. They are both cases where there's a cascade of electronic components which achieve a function in accordance with their structure and their values. And you can look at a device with a little more complexity, like a hardware filter. And those are often, of the kind you might find in a mobile phone, those are often designed by an iterative process, for which the parameters of the resistors and capacitors and the inductors are designed often by simulation through repeated iterations. But in my learned friend's case, those kind of filters would be considered a computer with a computer program. The computer program there being the values assigned to the individual components, having been determined by the iterative modelling analysis. But yet in my submission, that would be, again, extremely surprising, not what the legislature has in mind at all. No, I've mentioned a sextant. Now, the point is not to engage in a debate with my lady, my lords, about whether a sextant is a computer in a computer program or a filter is. We just say that the fact you can have this kind of debate about this broad definition or broad approach to a computer and computer program shows you two things. Firstly, that the functional argument my learned friend has, which is if it takes in information, performs something that can be provided mathematically and spits it out, is a computer or a program. It just shows that that is too broad and an unreliable touchstone. And second, we say, it does highlight that with his much broader approach, particularly one he advocated already yesterday, you reach results which are absurd, at least potentially absurd. One can look at this in another way, which is, if you dig a bit deeper as to actually what is going on, when my learned friend says the weights and biases of an ANN provide the computer program, if you take a hardware ANN, that can be implemented in pretty simple forms. It's just a useful way of thinking about it. Links are just tracks of wire. Weights can be just an amplifier or resistor. A node itself can be implemented just as a simple resistor. And a bias is just another probably amplifier component.
Just help me understand how that remembers anything.
How that remembers anything. Well, they have particular values.
Right.
The resistor, once you've trained it, that resistor will have a particular value. That amplifier will have a particular set of amplifiers.
The resistor only ever has one value, ever. The training can't change the value of a resistor.
Well, sorry, it may be a variable resistor. I've read about.
So it's a person turning a dial on a resistor.
No. So what can happen once you've trained it, you don't need a variable resistor at all. In training, you need some way of varying the resistance.
Right.
And I don't know the details. I've read about a thing called a MEMS.
It was simple. That's all. I don't think it is simple at all.
Well, in use, you don't need any of that variability.
Sure. I don't understand.
Okay. And that's really what I'm looking. In use, you don't. That's what I'm really focusing on here. Now, my learned friend's case, some of those components are computer, some are the computer program. So the track is a link, and that's a computer. The resistor on the track is part of the computer program. Now, firstly, they're all completely intermingled into a complex device, and we just say it's a complex electronic device. But then you've got to ask yourself, what are the instructions on his case? What he's really referring to, the individual current flows through the resistors and amplifiers, other components. But they're not passing instructions at all. They're just doing their normal job of increasing or reducing the current passing through themselves. Now, this may have a downstream effect on other components. Obviously, that's true. But in our submission, a downstream effect isn't to be confused with an instruction to tell another thing to do something, let alone to tell a CPU to do something. It's just doing what electronics do, and what electronics do in all of the examples that I've given, my lords. It's just that an ANN is a very big device, and therefore, consequently, much more complicated. But we do submit that you can't describe effects of that sort, namely, fracture resistor reduces flow and amplifier increases the flow, as an instruction of a type contemplated by the Act.
Can I just ask a question that goes back to what I was asking you differently, in a different perspective from what I asked before, and you gave me a very satisfactory answer to the previous question. But did you submit to the hearing officer that the exclusion of program for a computer was simply not engaged in this case because there was no computer and therefore no program?
Yes. Sorry.
Where is that in the decision?
I can tell, my lord, that was our primary submission to the hearing officer, or the first submission we made to the hearing officer.
Well, it all seems to be about hardware versus software. So I assume you're referring to paragraph 56 to 58. and then again in 59. But maybe you did make the submission there's no computer. The submission seems to be, as is recognised in 59, that there's no program as conventionally understood because there's no if-then type of instruction. That seems to be the way the hearing officer understood it. Not that there's no computer at all.
Well, at that point, it is true that before the hearing officer there was no debate as to the nature of a computer itself. That is something that Mr. Justice, Sir Anthony Mann, raised himself. Before the hearing officer, the focus... And
you hitched your bandwagon to that?
I thought he made a good observation and agreed it was correct, my lord, certainly. Actually, no, he said there was a computer. But certainly, before the hearing officer, the argument was about whether an ANN can contain a computer program at all. And before him, the argument was about whether or not there was a serial set of instructions of an if-then type nature, which is, and we relied upon the definitions that I've already shown, my lady and my lords, I think it's paragraph 36 of the judgment, we relied upon those from the hearing officer. And so we had, in essence, this discussion, but it hadn't developed in the same way that I'm now discussing, because that is a point that only comes out of the way my learned friend has developed it himself on this appeal.
Right, so but to be clear, I think the upshot is as follows. Your argument in this court is there is no computer, and that's why there's no program.
Well, my sixth point, I would slightly say no. My point, the statute says, is there a program for a computer? And I say there is not, because there is not a serial set. There is not a set or series of instructions for a computer instructed to perform a task, and so I slightly butchered those words. I've been asked to think about how I would define a computer, and I would say that, and I'll think about that over the short adjournment as to whether there is a computer or not, because as my Lord Justice Birss points out, the word computer can be used in extremely broad senses, such as to describe somebody working for NASA and doing serial paper constructions, probably using a logarithmic slide rule. So there's a danger of being too distracted by arguing about the exact outer limits of where a computer is, because I can see that intellectually, in one sense, you can describe a slide rule as a computer. It is a tool which computes things, they're logarithms. But I would certainly suggest that that is not the kind of computer the Act is contemplating. The Act is contemplating what, in common parlance, one would refer to as a computer.
But this is why you draw the analogy with the sextant, to go back to one of the examples you gave before. You say a sextant is not a computer, and therefore there's no program for that computer. So what I'm anxious to understand is whether your submission now is that a trained ANN is not a computer, and that's why you don't find a program, or whether you accept that it's a computer, but you say, nevertheless, it has no program because you don't find anything corresponding to a set of instructions.
So actually I take, if I made the third way, which is I say it's not a computer program, but in any event, even if it is, there is no program for that computer. So did I say computer program twice? It is not a computer, I apologise. It's not a computer, but even if there were to be, there is no computer program.
So,
which is in fact,
so you run it in the alternative.
Yeah.
You say, first of all, there is no computer.
Sure.
Secondly, even if there is a computer, there's no program. That's clear.
And Sir Anthony Mann held there was a computer, but there was no program. I'm sorry, I ran over.
No, not at all. But I am going to say 2 o'clock because there's clearly considerable ground to be covered. Thank you all very much.
All right, thank you very much.